going to be putting this video on YouTube. Yeah. Hi, everyone. I'm going to just give it a few moments. I think that's what people do. They let the people come into the live. So if you're new here, my name is Atiya Myers. I am the founder of the Atiya Myers Law Firm. I am based here in Los Angeles, California. I will be talking today about law that pretty much affects nationwide, just kind of your basics at business and trademark, and also just different agreements. So if you're not in California, some of these things might be helpful to your business and other places. I'm just going to give it just a few more, maybe like a minute or two before I kind of get started. If you looked at the post that I made, I'm briefly speaking on 3 different topics. First, I'm going to be talking about the trademark registration process, which hopefully you can see the photo on the screen. I'm also going to be talking a little bit about filing an LLC, where you should file that LLC, if you should file it. And then I'm going to lastly just be briefly touching on some very important agreements that you should take into consideration when you are starting your business. So if you can see the photo in the back, and if you can hear me, can you let me know? This is my first time going live, and it's a little different on the iPad than on the iPhone. I'm trying to see if I need to put my AirPods in for the microphone. Can you guys hear me? Yes. Okay. Thank you. Again, I will be saving this live on YouTube for people to reference later. And if there are questions that might take a little bit of time for me to answer here, I will address them later, either on another live or during a reel. So thanks, guys. I'm glad you all can hear me. I'm probably just going to go ahead and get started today. So my first topic today on Get Money Mondays is trademark registration process. So as you can see, the first step to that is definitely choosing a mark. So choosing a mark for your business might sound very simple, but your mark can be anything from your logo to your business title, or maybe a tagline. So for example, my tagline for my law firm is trade your problems for solutions. So those are the types of things that you can get trademark registration for. So first, that's what you do. You choose a mark. So you want a mark that is unique. You want it to be identifiable. So the purpose of your mark is to identify your trades, your services, your goods, whatever it is that you're selling to people. That's what you want your mark to represent. So with that, you have to be very cognizant on the mark you choose, because there's different rules that the trademark office follow before they can grant you registration for that mark. So for example, you can't have an apple selling business and name it Apple. We sell apples, for example. So that is kind of like what you would call a generic or very descriptive mark. It has to be unique, and it has to identify you as the sole provider of your goods or your services. So that's the first thing. And so trademark attorneys such as myself will kind of help you with choosing a mark by making sure that your mark is yours alone, because you can't necessarily have a registration for 2 of the same marks in the same class of goods or services. So what that means is that each trademark application is filed into a different class of goods or services. So if you're selling skincare, for example, that's one class, versus if you're selling purses or handbags, that's a different class. So you have to file your trademark, into the different services or classes that you plan on using the mark for. So these are all the types of considerations that you want to do, because there are several different classes in your trademark application. If you use the same mark for several different goods, there could be the requirement to file that mark in several different classes, and that can be very expensive. So then we get to filing your application. So again, the cost to file a trademark application with the USPTO is $250 or $350, depending on how you describe your goods or services. So attorneys will decide based off of what you're selling if you should have a more expensive class filing, which is the $350, where you get into a little bit more detail of your goods and services, versus a $250 class filing. That usually means that the USPTO already has a pretty good description of your goods or services available, which makes that application process easier for them. So those are also some considerations that you take into when you're choosing a mark and filing your application. The next step is what we call trademark prosecution. And so what that means is that it takes about 6 or 7 months for, after filing the application, for an examiner to get assigned to prosecute your mark. So what that means is that there is an examiner who works for the USPTO, and what that examiner does is it looks at your mark to see if it, like I kind of said, is it generic or is it too descriptive, or is there another mark already out there that's already taken. So it kind of looks, the examiner looks into all of that, and then the examiner will issue what they call a office action. So there's 2 types of office actions. There's non-final and there's final. So if you have a non-final office action that the examiner administrated on your, the examiner put out for your mark, then that means that you have the opportunity to correct the mark, or maybe you have the opportunity to argue that, well, my mark isn't as similar as this mark, or my mark isn't confusing for these reasons. So depending on the complexity of the arguments that the examiner is making, it can be a very difficult thing to convince or to get your trademark into the next step of the process. So you usually are administered 2 to 3 maybe non-final office actions before you are administered a final office action, which basically says that prosecution is over and that they will not be accepting your mark. But let's just say that you were lucky enough and your attorney was good enough to get you to the next step, which is publication. So this process can take up to a year, minimum maybe. I'll say maybe 10 to 12 months, depending on the complexity of your mark. If you have a fairly simple mark and there's nobody using it and it's not generic or descriptive or anything like that, it's probably about a year. But it can take longer depending on how many office actions you have, if you decide to appeal, and maybe you have an opposition. So you might be wondering what the opposition is. So once you get your mark to the publication stage, what happens is that the USPTO will publish your mark in what's called the Gazette. And it's basically a publication where other trademark attorneys who work for whatever different companies that they work for, they monitor all of the marks that get published into the different categories that maybe Coca-Cola works for, or maybe that Tesla works for. So these companies have attorneys who basically they patrol the marks that are published to make sure that your mark, for example, is not imposing on theirs. So let's say that some company does find that your mark is imposing on theirs, and then they can file an opposition. And for the opposition, they will say, hey, we don't want your trademark published for XYZ reasons. So that can also become a very lengthy and expensive process. So it's really important to, at the first step of the choose the mark stage, that you choose a mark that will kind of avoid all of those things and those repercussions later. So let's say you make it through the publication stage, and then next is the registration stage, where the USPTO and you yourself agree that your mark is good, it follows all the laws, it's not confusing, and then you get your registration. And so with registration, that's not something that is permanent. You have to renew your registration, you have to show that you still use your mark, and you have to have like maintenance on that mark, and it will be better to have an attorney to manage and maintain your trademark portfolio, so that you have an attorney who's watching the Gazette and watching everything that's being published, so that way you can protect your rights and stop somebody from imposing on your mark by maybe getting a similar trademark in the same class. So that's briefly a very high overview of the trademark registration process, given that let's just say this very small, low complex level. So again, that takes about a year from start to finish to do, and it can be very complex depending on how contentious your mark might be in the market. So that is the first topic that I will be discussing. So if there's not any questions on that, I will go to my next topic, which is where to file in LLC. So I get this question pretty often on, do I need to file an LLC and where should I file it? There are some, well, I guess for the first question, do you need an LLC? That question definitely depends. Definitely depends on your services. So you might be familiar that you have the option to be a sole proprietor. You also have the option of having a corporation or a partnership. But the LLC, which is the limited liability company structure, is very popular for many people because of the benefits it offers in shielding liability, and also with the tax benefits that you get from having an LLC. So the biggest question that I pose back to people when they ask me, do I need an LLC, is I ask them, what is the worst? I'm actually going to answer your question. Sorry, I have a question before I dive into that. If anybody can see the question, it says, what is the total cost for a trademark? So that depends. So a trademark can be as low, trademark registration can be as low as $250 if you do it yourself and you're able to get the mark from the application standpoint to the registration page, the registration portion. You do not need to be an attorney to file your trademark. You can do it all by yourself if you are the owner of the mark. So at minimum, it can cost you $250. At maximum, it definitely does depend. An office action can take an hour or two, maybe a day to respond, again, depending on the complexity. And then you have hours of attorney time that you're adding. And also because it's a year-long process, pretty much from start to finish on a simple one, I would say a cost for a trademark is at least $1,000, not including fees, if you are using an attorney. There are different options, of course, and different packages and things that you can negotiate with attorneys, but it would definitely just depend on the complexity of your mark and how easy, quote unquote, it is to actually get it to registration. So I'm just going to jump back now to the LLC question, which was, do you need an LLC, and how do you know if you need one? And the question that I always pose back to people when they ask me, do I need an LLC, is what is the worst that can happen? What is the worst that can happen from your product? Are you selling socks and the worst thing that can happen is somebody slide down the steps on your socks and blame your socks for it? If that is the worst thing that can happen, then if that's very impossible to happen, then maybe you don't need an LLC. If you are serving people food, for example, and there's a big risk that you can get 100 people a day you serve a plate to, and out of those 100 people, one of those people can get sick and sue you. So that is really based off of the risk level of your LLC and how much risk are you really willing to take from it. So if you have something low risk, which it might be selling socks on the street, that's pretty low risk. But if you have something that's pretty higher risk, like I said, selling food, cooking food to people, things like that nature, then you probably definitely want to look into an LLC. And then also too, you're looking at your revenues as well. Is there something that you want to get the tax benefits from, or are you not? Or Is it something that's, you know, pretty low revenue, pretty maybe a side hustle, and that you don't need the full LLC regime and scheme to you know, secure liability for your business? So that's always the biggest question. What's the risk? Do you need it? What's the worst that can happen? So if you say, hey, you know, I have a pretty big risk in my business because I sell food. Because I sell food, I want to make sure that if I get anybody sick and they sue me, that I'm protected from liability in my personal assets. Because ultimately, that's what an LLC is. It protects your personal assets from anything that the business might have its hands on. So that goes to the question of which state. So my best advice always is to tell people to file their LLC in the state that they live in. That's the safest bet for you to do because you live there, you're paying sales taxes there, you're following the laws there, I would hope and assume. So that is usually the best bet. There comes a time sometimes where you might say, hey, I don't want to file my LLC in California because, for example, California has an $800 a year annual tax on your LLC. Regardless if you made negative $800, if you made $8 million, it doesn't matter. You are going to pay $800 a year flat fee tax on that LLC. Versus in Georgia, where I believe the fee is, I think $51 maybe for annual fee. Is definitely less than $100. So these are types of the considerations that you kind of take into which state. But the downfall of you using your Georgia LLC primarily to have a business, a California business, for example, would be if you were to get sued, you are automatically, for 99%, more than likely going to be able to get sued in whatever state that you filed your LLC in. So if you filed your corporation in Delaware and you've never stepped foot in Delaware, if you get sued in Delaware, there's pretty much no way that you're going to avoid the liability in Delaware and whatever the rules and the laws of Delaware have for their state applying to your LLC. So those are pretty much the considerations that you kind of take in when you're deciding on which state that you want to file. Always, like I said, the safest rule is to file your LLC wherever you practice. That is the best place to do it. It is the safest place to do it for the most part. So that way, if you're getting sued, you will be able to be in that location to advocate and defend your business. I have another question as far as, is there a benefit to having a corporation over an LLC? It really just depends. It depends on what type of business that you have, how many people, and really the biggest difference off the top of my head between an LLC and a corporation is the taxation. So the taxation on a corporation is taxed twice. You're going to pay the corporate tax, and then it's going to be taxed again through dividends to the shareholders. So it will really just depend on what type of business you had. Again, the LLC is it's very preferred by people, especially those who are single members or don't want to have a formal partnership. The benefit of the LLC is that you can contract a lot of the like the limited liability law. You can contract around it versus you don't have that same freedom with a corporation. It's a little bit more sturdy, for example, a little bit more rigid. So that's why an LLC is so popular, because of the flexibility that it allows. And the next question I have is, can you operate and file your LLC in 2 different states? So you can have one LLC, for example, like Google. Google is an LLC and they do business all across the country. So yes, you can, but see, for example, Google, because they do business all across the country, they are pretty much could be eligible in certain cases to be hauled into court across the country. So those are kind of your things. If you have 2 different LLCs, so let's say you have an LLC in Georgia and an LLC in California, you're going to have to follow and pay the fees for each of those separate LLCs. You can also have, you can get very detailed, and you can have an LLC own an LLC, and you can set up corporate structures that way as well. But it really just depends on what your business needs and what you're trying to shield and protect it from. And okay, I think that's it for the most part briefly on LLC. So then I'm going to go to my next topic, which is important agreements. So for the most part, you want to make sure that your small business has really rock hard, solid agreements. And this doesn't mean go to LegalZoom and download them. There's so many different websites, and free for the most part, or very cheap, maybe $20-$30, where you can get shell agreements, and you can just fill in your name. The issue with that is that a shell agreement typically isn't well thought about for your unique business situation in need. And that's why it's always kind of better to have an attorney to do these things for you, to review these things, to explain to you what exactly is happening and how exactly, because at the end of the day, your agreement has to be court sturdy enough for you to win on it in your favor. And if you have an agreement that you downloaded, there's nobody really going to be there to say, yeah, this agreement will win on your behalf in litigation. Because at the end of the day, if you can't win and litigate on the agreement, if the agreement is breached, then the agreement has no purpose. It's just a page full of words. So the agreements are what you take to court to argue when somebody's not holding up the agreement. And so if you kind of look at it from that standpoint, and especially how expensive court is and how expensive attorneys are, and you want to win in court. And so in order to win in court, you have to put some of that aggressiveness into your agreement, so that way you can do just that. You can win in court. Because if your agreement is ambiguous, there's a chance that the court is going to side with the other person. Now you're out of whatever it is that you're arguing for, and you also just have an agreement that means nothing. Like, it's just words on paper. And so that's why you kind of want to get an attorney to at least review these things with you and let you help decide which risk you're willing to take. And so just the first agreement that I'm going to briefly discuss is an operating agreement, which is the framework for your LLC. So kind of how I was discussing, how you can contract around a lot of the LLC law. Your operating agreement is going to help you do that. So if you're a single member LLC owner, you really want an operating agreement because it shows the so the operating agreement, if you're a single member, it definitely shows an investor that you're serious, and it shows your investor that, you're not just willy-nilly making decisions, that you have an operating agreement that you agreed with yourself of how you're going to run your business. So it's like an agreement between you and your business, for example, and it shows like investors and other people that this is what you agreed to with yourself, and this is what you're willing to follow. And so it just kind of makes your business look more legit and more solid. I see another question in here as far as the difference between S Corp and LLC and corporations. That's kind of just a whole different topic. It's just kind of a different topic that I wasn't planning on getting too in detailed in here. But again, your biggest difference between your S Corp and your LLC is definitely taxation. I have another question as well as far as who can draft your operating agreement. That depends. I would be more comfortable drafting operating agreements for California California LLCs, because I'm drafting them under California law. So I would definitely say you would want an attorney that is in the state that does business law in the state that you're in to draft, because different states have different LLC laws. So that is definitely what I would do. That's something that you don't necessarily have as well when you do a legal Zoom. You're just going to put California, and it's going to give you the legal jargon that it kind of just remixed from the statutory scheme on LLCs. And so that's why you kind of really do want an attorney that's able to that has read them, that understands and can give you options on what you really want, despite the generic kind of jargon that you get from downloading. And that's the same thing as with the operating agreement as well. Definitely want to be able to know if you have more than one member, who put in what investment, who's going to do what happens if somebody unfortunately passes away, how does their family, does it sell automatically? Does your family get the piece of your LLC? These are the types of things that the operating agreements are drafted for, and you kind of do want an attorney in your state to do that for you. The next question, or the next type of agreement as well, is a work for hire. So if you have a business and you are, let's say you hire somebody to do your logo, you kind of do want an agreement that says, hey, I'm paying you to do this logo, and the logo is now mine, and the logo is not yours anymore. And so that also happens for, let's say, if you are a screenwriter or a producer, film producer, for example, and you've hired a script writer to come in and help you with writing a TV show series. You really want to get a work for hire agreement that basically lays out how much you plan to pay them, what kind of credits they're going to get, and what they're going to owe. And you kind of, like I said, you want to do this for anybody who's creating art for you or creating things for you who isn't necessarily an employee on your payroll, where it's some type of employment agreement. So if you're paying people for things and it becomes like an IP or things that have some type of value to you, work for hire agreements are just really simple releases of whatever it is that, hey, I paid a flat fee or whatever for this, and now this person doesn't have any rights to it anymore. So that's another important agreement that you want to have if you have people paying and creating things for you. And that also kind of gets into the IP transfer agreements. These are important agreements that you want to have. So, for example, if you yourself, so I'm Atiya, and I created a trademark for a business, and now I want to assign my trademark to that business. So now I no longer own the trademark, but now the business owns the trademark. And so that gives your business value. The IP transfer to your business is giving your business value. And so you want to make sure that you do that if your business is housing. If it's just as important as if you were giving your business property, like physical property, as the value. So this could be for patents or copyrights or different trademarks or trade secrets, for example. You can assign all of those rights to your business and start building your business's value as in that space as well. A work for hire agreement can have non-disclosure or confidentiality clauses in them as well. But I always want to try to caution people with confidentiality clauses or NDA agreements, because the question is, when you get to court, let's say the person has breached your NDA or breached your confidentiality agreement. The question for the court that they usually grapple with is, how much did you lose, or how much was that breach worth? So you might want to argue that the breach has cost you $100,000 in damages from this person breaching, but that's just something that you have to prove. And so it's just something to really keep in mind when you're writing these NDAs or you're signing these confidentiality agreements, because you might have heard stories of big companies who sign these NDAs, but still somehow they use the person's whatever, but it doesn't get that far in litigation because the people cannot afford to litigate against them, one, and then they don't have a really good grasp on how much the confidential information was worth. So you kind of have to show the damages that you had, and also too how much they were enriched from your information. So that's kind of the things that, you know, just to kind of also as well keep in mind. I look at most of these things. So there's like litigation and there's transactional work that attorneys do, and I do my personally transactional work from a litigator's standpoint, which I personally think is an advantage because, like I said, at the end of the day, if the agreement doesn't hold up in litigation, and it was worthless, it was just a bunch of words. And so those are just kind of the things, like the long-term strategy. And agreements can expire. So, for example, some confidentiality agreements can expire where they have to be silent about something until it goes public, for example, or until maybe 6 months after. So it kind of just depends whether they expire or if they're forever. It definitely kind of depends as well. Or if the agreement itself was terminated through a breach, then maybe it expired in that standpoint. So it does that expire if the agreements expire. It definitely kind of depends. And I'm sorry that I say stuff depends all the time, but that's the go-to lawyer phrase because it really does depend all the time on every single fact. But I think that is my 2 cents on the topics. So if I don't have any other questions, so just to go over, we did the trademark registration process, and then talked a little bit about why you need to have your LLC in your state, so that way you're not calling Delaware attorneys and never step foot in Delaware and being sued in Delaware. So you don't want to do that. So you want to file your LLC where you live. And then lastly, just some very important agreements, which is your operating agreement, work for hire, making sure all your IP is transferred to your business so you can start building your business's monetary value from the beginning. And also too, just making it all more legit, making it rock solid. Agreement, like I said, contracts and stuff really might not seem that important until it's time to litigate on them, until they're breached. So yeah, thank you all for coming. If I don't have any more questions, that was my first Get Money Monday. Hopefully it helps somebody. And yeah, if that's it, then I'm signing off.